Okay, final case on the docket, Brown versus Brown. Okay, you may proceed.
You start the clock awfully fast. Good morning, may it please the court. My name is Jamie Bellotti Moses from the law firm of Holland and Knight. I am here on behalf of the appellant, Pastor CLINT Brown. I would like to reserve 5 minutes for rebuttal, if that is okay with your honor. We are here today seeking a reversal of the order of indirect civil contempt. Briefly, the facts are that the parties entered into a marital settlement agreement on September 29th, 2005. Pursuant to the MSA, my client was ordered to pay $25,000 a month in non-modifiable alimony.
Ms. Moses,
Yes, sir.
can we focus on, I believe your client admits that he did not comply with the required payments pursuant to the MSA. Is that correct?
We do not deny that there was an order in place and that after 8.5 years he was not able to comply.
Okay. And that's due to your position, your client's position is due to a change in financial circumstances, a change in his income.
Yes, sir.
And so the issue that I believe that we're here on, and you correct me if I'm wrong, is we're here about the failure of the court to find an ability of your client to meet whatever the financial obligations were under the MSA. Is that correct?
Yes, sir.
Okay. So are there any other issues that we should focus on?
Well, there are two. Number one is the failure to comply with Rule 12.615D1, which requires the specific findings of an agreement, a failure to comply with the agreement or court order, the ability to pay at the time and not paying, and then later the ability to pay any ordered amount.
The ability to pay at the time, I believe, wasn't there an issue with regard to a $40,000 credit card bill that he chose to pay as opposed to paying his alimony obligations? Is that correct?
Well, the testimony was from my client, who is the only one that could have spoke to that, is that those were family bills and the money came from his wife. It was not his money that he chose to send to the American Express bills versus his former wife. But that would have only been with respect to, by the time the contempt motion was filed, he was 2 months in arrears. And by the time the hearing happened, or the judgment was entered, we're a 1.5 years post. But that was a disputed, it was my client's testimony versus the argument of the former husband. There was no testimony that it was his money that paid the American Express bills. The only testimony, and it was not refuted, was that it was his wife's money that she brought to the marriage, and they paid the American Express bills that were her bills as well. There was also, the trial court did not believe the testimony regarding the automobiles that my client owns but doesn't pay for, and that they will revert back to the church. The testimony was that when he, or in order to get the car loans, that he is the one that had to be the guarantor on them, and he was able to use them as long as he was the pastor for the church. However, the payments were made by the court, or by the church, and they were the church's cars when it was over. For some reason, the court did not like that testimony at all and found it unbelievable and suggested that somehow that meant some sort of income to my client. Now, for IRS purposes, it might have been income, and even his accountant testified that. But for purposes of cash in hand and being able to settle satisfy his obligations under the MSA, that does not equal money in my client's hands. And if you look at his financial affidavit in the record at 772 to 782, he doesn't put as an expense those automobiles. And granted, we may not like the facts in this case that we're talking about $25,000 a month of non-modifiable alimony, or that he has access to 4 automobiles, but the issue is whether those automobiles somehow constituted income to him that he could have paid his former wife, and it clearly was not. But
His automobiles were in his name? The
Excuse me.
automobiles were in his name?
Because the court, it was, the history of the case is that he was the pastor at Faith World, and when it collapsed, I might say it wrong, the new ministry could not have credit for anything and could not obtain the loans for the automobiles to be driven. So it was put in his name, but the church paid it off, and after...
But they were in his name.
They were in his name, but he didn't declare them as an asset, nor did he declare them as a liability. The suggestion was by opposing counsel, oh, the church pays for these automobiles, you suddenly have access to $3,500 a month more. That is not true. His expenses were his expenses regardless of the automobile obligations, and he never put them down as his monthly expenses. I agree, if he had put them down as monthly expenses and tried to argue that because of those expenses he could not pay his obligation, then I could see the trial court saying, wait a minute, you're trying to pull a fast one on us. You actually have access to these funds. That's not what was done. If you look at his financial affidavit, he has not put them down as liabilities because he does not have a right to get to the equity in them, nor did he put them down as... he didn't put them down as assets, nor did he put them down as liabilities. But for some reason, that really infuriated the trial court. But the statute is, or the rule is quite clear, 12-615-D1 says that these specific findings have to be made. The trial court did not make a specific finding at the time of her ruling that my client had the ability to meet his obligations or to satisfy the $250,000 he was ordered to pay within 120 days. I have cited in my brief a significant amount of case law that finds if these findings are not made, it's automatically reversible because those findings need to be made. And I want to stress to the court, we are not denying the obligation is there. We are not asking the court to rewrite the MSA. That is not what we are doing. All that we are doing is seeking a reversal of the order of indirect civil contempt because the trial court failed to comply with the rule, which is quite clear what has to be found. The second issue on appeal is that part of the $250,000 purge amount includes what was contained in paragraph 12C of the MSA, which referred to lump sum alimony and equitable distribution. And he,
Was
yes,
that
ma'am.
raised below? The equitable distribution argument, was that raised below?
Not as artfully as I had hoped.
As a no?
Well, no, the problem, as my understanding of the transcript, and I was not trial counsel, and I know that's not an excuse, Your Honor, but when I read the transcript, it was sort of presented as this is the amount that's owed under these two provisions. Like you, Your Honor, I recognize that on the printout that was offered as an exhibit, plaintiff's counsel, or I'm sorry, the former wife's counsel just referred to it as lump sum alimony, but it clearly arises out of paragraph 12C.
But that wasn't brought to the attention of the court, that wasn't argued below that you can't have this because it's equitable distribution. That argument was not made below.
Not as artfully as I had hoped.
You waived it up here if you haven't raised it below.
Regardless, that is not the majority of the amount. The true, over $200,000 of this is the alimony payment. I would also like the court to know that when my client's income reduced significantly, he still continued to pay the former wife over $10,000 a month. So it's not as if he just stopped making payments. He actually continued to pay what he could pay, which this payment is over half of what he brings in and is definitely more than his expenses every month. Again, All that my client is entitled to is the proper findings to be made by the trial court. We do not believe that the trial court can make those findings and couldn't have after that hearing. This is not an order that was presented to the trial court for her just to sign. She wrote this order, and therefore it should have contained the appropriate findings. The absence of those findings, I don't know why, but she makes no effort to find that he had the ability at the time the verified motion was filed in July of 2014 to make the payments, nor did she make any effort to determine that at the time of her order of indirect civil contempt that he could make these payments. And she didn't go one step further to find that he could make the $250,000 payment. That is completely absent, and therefore under the case law is reversible. And then briefly, the case law is also quite clear that any speculation as to what the former husband might have access to cannot replace the findings that are required. And that's evident in the Abaruso case. That was a case about the former husband. The former wife argued that the former husband had access to his sister's business funds because he worked in his sister's closely held business. And the trial court found that the testimony regarding his inability to access his sister's funds was incredible. And the court still found that even if you find testimony incredible, it does not excuse the requirement to specifically identify a source of funds to pay. And she never did that. Even if we accept this $40,000 for the American Express bill, there are no findings regarding the remaining $210,000. Absolutely none. And therefore, the court just failed to satisfy the rule. If I may, and I see there are no questions, I'd like to save some time for rebuttal if the court will allow it.
Very good, thank you. Your turn.
Your Honors, the appellant alleges that my filings with this court are nothing more than a simple statement of disagreement with his appeal. None of my dealings with the appellant have been simple. I have not and cannot concede to lies. My arguments are not irrelevant because I have no high-powered legal team. As a high school junior, I met Mr. Brown through the church where my parents were pastors in Jennings, Louisiana. I was 17 when he told me that if I did not marry him, he would be leaving town to travel and play piano with a group. We were married in 1984, a week after I graduated from high school. My life became his to control, and control it he did. After moving to Columbus, Ohio, our daughter was born on February 18, 1989. I was 23 years old. On July 5, 1992, our son was born. There were many moves between Louisiana, Ohio, and Texas early in our marriage with 2 small children. Eventually, we moved to Orlando, Florida in 1993, where Mr. Brown wanted to start a church, and this organization became known as Faith World. As a wife and mother, I raised our children, cared for our family needs, and assisted my husband in whatever capacity he required. The music conferences and ministry events were like full-time jobs. In addition, we recorded many music projects, including a co-produced children's album, and I also had a solo album that was recorded in 2001.
Ms. Brown, we're here concerning the order that was rendered by the trial court. Specifically, we're focusing on whether or not there was a finding made by the trial court concerning your ex-husband's ability to pay any sanctions. So let's focus on that issue. Would you admit that the trial court did not make that specific finding as far as at the time we're talking about now, after the MSA, the marital settlement agreement has been in effect for a while? There's at least been an allegation of a change in financial circumstances. And the trial court, according to the rules of procedure in the family law area and the case law, the trial court's got to make a finding as far as the ability of your ex-husband to pay. Was that finding ever made and put in writing in the form of an order by the trial court, to your knowledge?
I believe that the lower courts did recognize that his testimony was considered unbelievable. That's what the judge said.
Okay, but there was no specific finding as far as his ability to pay whatever amount going forward. Is that correct?
I believe that there was. I believe she did.
Is it in writing? I
Is
mean,
it in
I
writing?
realize that
I think she made it clear, the judge made it clear. I have written here that, that my ex-husband, mere assertions of present inability to pay that order of support can't be taken as a conclusion. Although she didn't specifically state that, I think by stating the fact that his testimony was not considered credible because she couldn't find any credibility with the inconsistencies in his testimony. His financial affidavit was inconsistent. His own accountant she gave her testimony, and it was nothing like his testimony. There was a lot of inconsistencies. There was omissions. I believe that based on the testimony of the former husband, the judge made the best ruling she could make, and I felt like she was very clear that there's no credibility here. There's absolutely no credibility here, and the court, regarding credibility, I have written here that it requires a particularized showing of specific changes in financial position since the date of the last order and of present income and assets. The court must then evaluate the evidence, including credibility, to determine whether it sufficiently justifies a finding that Mr. Brown has the present ability to pay and has willfully refused to do so, and I believe that was the case. I don't believe that he proved that he didn't have the money. He showed where the money that the agreement, the marital settlement agreement that he and I both signed and agreed to, that he agreed to stick to that agreement. I agreed never to go back after any more money. I said I would never pursue anything, no matter whether it grew and he developed to have more income or not. I willingly signed that paper and trusted it. I trusted that marital settlement agreement to protect me. And I trusted that the judicial system would protect my best interest. And I trusted it and I believed in it. And when he signed it, I walked away from Faith World. I gave up all my rights to what we built together for over 19 years of marriage and 2 children. And I walked away from it, and I never fought for it. I never did anything to go after anything more. I just wanted what he agreed to in the marital settlement agreement. And I don't believe, and I don't think the judge believed, that he could prove that he did not have the income to make that. She, or my attorney at the time rather, was able to prove how he willfully chose to pay other obligations that were not required by law to pay. The marital settlement agreement was a law. It was required for him to make those choices, but he made conscious choices against the law. He made a mockery of this marital settlement agreement, and he made a mockery, in my opinion, of the court. And I believe that the lower court judge stated that in her ruling by saying his entire, I don't want to misquote her, but she said that that Mr. Brown's testimony as a whole is unbelievable. I will continue. That as a wife and mother, I raised our children and I cared for our family needs and assisted my husband in whatever capacity he required. I talked about having a solo project in 2001, and I was not only paid for any of those, I never received contribution for any of my services at Faith World and in our marriage. I never worked outside our home during our marriage, and everything I did outside of the home in some church or ministry role was as his wife. On February 3rd, 2003, when my children were ages 13 and 10, Mr. Brown left our home with a "see you later" as if it was an ordinary day. And in the process of cleaning our home, I saw a large brown envelope on my pillow. I opened it to a typed letter notifying me that he wanted out of the marriage. I found out later that he had recruited our babysitter to type the letter. And as the divorce progressed, misconduct and mismanagement of finances at Faith World were revealed, in addition to other questionable conduct of Mr. Brown that caught the attention of local and national media. My children and I were hounded, and the negative press made it impossible to get any work, especially with churches or ministries, which were the only places I had any experience. My children and I lived in a downward spiral as I faced litigation from Mr. Brown and backlash regarding Faith World. At the time of the original agreement, Mr. Brown got the marital residence, and I moved with the children to another home, hoping to shield them from further media barrage. They were still hounded. Mr. Brown had no child support obligation to pay, and the alimony of $150,000 to be paid in annual installments of $15,000 for 10 years was intended to make it possible for me and our children to have a place to live and be rehabilitated. For me, rehabilitation meant starting from the bottom. I had no education beyond high school. I never had so much as a checking account or utility bill in my name. I had zero savings and no retirement funds. I had no experience with how the real world worked, and the taint of our family left me with no friends to turn to for practical advice. Our children never really recovered. My daughter had to be pulled out of public school because the media stalked her there, and when we tried to put her in a private school, not even a Christian school would take her. After much struggle, the only option left was to obtain a GED. The children were damaged by the revelations concerning Mr. Brown's misuse of church funds and the reaction of the public to their father's conduct as a husband and as the leader of Faith World. One adult child currently still lives with me. Since no one would hire me, I had to gain the skills and education necessary to make a living on my own. And since their father spent much time traveling, the minor children were mainly my responsibility, and becoming self-employed seemed like the best way to be there for them. Once the youngest graduated from high school in 2010, I had more time to pursue my education. I eventually received multiple certifications through the American Fitness Professionals and Associates and a holistic MBA certification. By that time, the economy had already turned negative and it was difficult to generate income. Every attempt I made to sell my home and downsize over the years was unsuccessful and set me back financially. When the real estate market began to improve in 2016, the home finally sold in December 2016 for enough to pay off the mortgage. Mr. Brown's breach of the marital settlement agreement and failure to pay what he promised made rehabilitating my life nearly impossible. When Mr. Brown abruptly stopped paying alimony, forcing me to go back to court to seek compliance with our marital settlement agreement and enforcement of the divorce final judgment, I may have been naive. I had kept the terms of the agreement and assumed Mr. Brown would too. Mr. Brown chose to breach the marital settlement agreement. Instead of being rehabilitated, I was forced to use everything I had to access the court to seek justice. I can now look back and see that he was doing what he had always done. He ignored his legal obligations in a way that harms others. He did it to his children, he did it to his own 1,000-member congregation at Faith World, as he used the church for personal gain and hiding finances. He breaches contracts and he breaks oaths. Mr. Brown never denied that the amounts owed to myself, Miss Brown, is alimony. Mr. Brown never sought to have it determined as anything else because it was alimony. Of all the testimony taken in the lower court, including the testimony of Mr. Brown's own accountant, lies, discrepancies, and omissions were highlighted and specific instances were identified in the lower court's findings in the order of indirect civil contempt. In one statement, he would go from saying he had no money to saying he had thousands. His own witnesses and the evidence presented showed that he had more, not less, ability to pay. The findings were based on credible witnesses and evidence. The judge found Mr. Brown's testimony as a whole unbelievable. To my understanding, one function of a trial judge is to decide if a witness is credible. Mr. Brown was not a credible witness. Mr. Brown lacked credibility when he testified in the lower court. He lacks credibility now. He has ripped off the church. He should not be allowed to rip off the court. He should not be allowed to abuse the judicial system or make further gains from being unbelievable. And that's all. Thank you.
Okay, thank you very much.
I understand and appreciate the court's indulgence of Ms. Brown, but I hope that the court will recognize that
Yeah,
the
we understand the issue and,
majority of that was not within the record.
yeah, I understand, we understand all that.
Okay, the only thing, that I would ask is that the court recognize that he did not abruptly stop paying alimony, that alimony payments were made in excess of $10,000 per month, which was what Pastor Brown was able to make. I would ask the court to review the order. It does not comply with Rule 12.615D1, and that the court reverse with instructions that the trial court hold the appropriate hearing and make the appropriate rulings. Thank you.
All right, thank you very much. Okay, one recess.